University of New South Wales will be presenting on her project Mapping Weaponised Trade. Then we're going to have McDonagh from the Edith Cowan University, whose presentation will be covering national security, US trade tariffs and the WTO, a case of geoeconomic competition in a new economic Cold War. We'll then have Gustafsson from the European Commission, who will talk about China's expanding economic security paradigm and implications for the world trading order. And then we will have Yuka Fukunaga from Waseda University, who will be talking about economic coercion from a broader public international law perspective. We're going to start off with presentations by each of the speakers. Then we have a little bit of a structured conversation to draw out some common themes before we'll open it up for a general Q&A. But now over to Lisa.
Good morning, everyone. Thank you for joining us. So I just wanted to start with a little bit of context about the project before we introduce some of the results. So in 2020, the Australian government's strategic update for what I think is for the very first time had significant attention to trade issues as a national security concern. It notes the rise of coercive activity, including the rise of what it called the coercive use of trade and economic measures, or that is the accent, in the grey zone. In other words, activities sitting between the level of accepted political influence and activity and the other extreme outright conflict. And at this time period, of course, large period of high tensions and conflict between Australia and China, and some rise of economic incidents between the two countries, along with those political tensions. And so it was in this context that our project team received funding to map and ways in which the international community can navigate that industry. So this funding, in our case, came in the form of Defence Department Strategic Policy Grants Program funding, and the project is now near completion, and one of the major outputs is what we believe to be the largest open access database of its kind, curating international instances of weaponised trade and economic coercion. So I'll speak briefly about some of the key findings from the data set and the mapping exercise, and hopefully this also serves as an important for the rest of the panel, what some of my fellow panelists to say. The database itself is really available. Its address is simply economiccoercion.com. Please excuse in advance the sort of basic level of the website, because that is down very much time participants, which are not participants. The methodology is also set out fairly comprehensively in the database, so I won't take too much time to talk through in that. However, we did make an effort to include all case studies that we can find through a sort of a comprehensive search, where weaponised trading was alleged in the 20-year period from 2005 until 2024. So we closed the data set at the end of 2024 for reasons that are probably fairly obvious to most of you. Now, our objective in curating this data set was not to have an objective standard for what constitutes weaponised trade beyond your definitions, or to judge the calibre of claims for weaponised trade for the database entries. Rather, our interest was who alleges weaponised trade, in what circumstances, and what response, if any, is made by the alleged situation. So really, in effect, what we were trying to do is to identify the narrative contours of what the international community might consider to be weaponised trade and coercion. So turning briefly to some of the high-level findings, and again, you're all very welcome to use the database in any way it's useful to you. There are search terms that you can click through to find instances that correlate with some of the remarks. So in terms of sectors most targeted, perhaps unsurprisingly, goods that are subject to intensive SPS requirements become a prominent target for weaponised trade. So because SPS requirements of applications enforcement of those requirements in ways that can very easily delay or deter imports. Products that have a high cost attached to switching markets are also especially vulnerable to targeting. Of course, top of the list there would be perishable food. Fruit was food for a very, very large percentage of the case studies that we identified. But also vulnerable is anything that is configured for a low privilege or has very specific labelling requirements attached to the market. So clearly in this context, wine and spirits will enter section 7. As we know, from retaliation in WTO, wine and spirits have also a cultural cachet that make them desirable as a target in retaliation. And the same seems true in the Australian context. And this is certainly something that Australia experienced in relation to wine exports to China. And wine and spirits, of course, fall into another interesting category of luxury goods. And the hypothesis there is that it's critically palatable to withhold or increase the price point of luxury goods in the weaponised country without the risk of continued blowback. In terms of the types of measures that were came through most prevalently in the database, it's really a very large range of measures coming up. Everything from formal bans that run into threats of consumer action and eventually money. Formal measures included things like export bans, e-licensing procedures, and those were commonly technological products in particular. Also common was increased officiousness in respect of otherwise legitimate rights. So enhanced investigations, enhanced safety, as mentioned. Other types of informal punitive measures included unexpected delays, again, yes, accusations of tainted merchandise, but it was also important not to overlook impact on services. And that took the place of warnings bans on things like tourism, media, one of the most interesting examples that honestly would warrant an entire sort of 1 hour presentation in its own right is the removal of this China's customs database in 2021. And I like to think of that as a particularly good subject of study of weaponised trade, and I've done that vicious weaponisation because the level of subtlety, malleability, and the plausible time. Finally, made to cover the time that I is alleged political motivations. And these were not the main sort of subject of our study per se, but we have things data. So, unsurprisingly, Australian issues arise in the context of otherwise deteriorating relations between countries, and usually in the context of multiple grievances between the two countries. So Australia-China relations, for example, very complicated of disgruntlement in relationship on both sides. Similarly, tensions between Colombia and Venezuela. So it's, I think, both important and significant to understand not, the importance of not flattening out these studies and trying to actually always to progress. Territorial disputes are also multiple Australians. For example, Indian oil, which was attributed to statements by the Malaysian Prime Minister referring to invasion and occupation. Engagement with countries' geostrategic priorities, and also the country of which is trying to encourage a state to realign itself, to not continue to further align itself with geostrategic priorities. And then finally, security lines into terrorism type questions, examples of that. So I think that is a quick overview to make time and questions to cover one other things, but I think I just want to say, in terms of target countries and alleged perpetrators, that really most countries, most regions are quite represented. It's not as broken one particular state or another to target rivals, and the most major players in all of them alleged being the recipients of weaponised trade measures as well as being themselves. So thank you for your time. We have been.
Thank you, Lisa, for that very interesting starting point. Okay, so I'm going to discuss economic security, the emergence of economic security as the preeminent paradigm ordering the international economy, and address what the issues are for the WTO. The key issue for economic security within a multilateral setting is being able to distinguish between essential security interests on the one hand, versus actually protectionism on the other hand, right? And a lot of the initial debates around this are often falling back into these old dichotomies of protectionism versus liberalization. I think it actually muddies the water for the kind of new criteria and issues that we're having to address. So the original 2018 Section 232 tariffs on steel and aluminium are actually a harbinger and a very important case, both for change of directory in the US's domestic settings, and also because there was a WTO case that actually trying to address this question of what are the limits of Article 21 security exceptions, and that's going to become an increasingly key question in the world we're now in. Okay, so today I'll briefly look at the Section 232 powers, just to give a bit of context for this. Then we go into the WTO challenge and what they can and actually I'll try to interpret the limitations of Article 21 in the context of the US argument for essential security interests. So the Section 232 of the Trade Expansion Act of 1962, so this was the peak Cold War era, right? So that's actually useful to keep in mind. They sets out the scope for an investigation into essential security interests, and it's quite broad, right? So I'll give you some of it. Without excluding, this is a quote from the law, other relevant factors give consideration to domestic production needed for projected national defence requirements, the capacity of domestic industry to meet such requirements, existing and anticipated availabilities of the human resources, products, raw materials, and other supplies and services essential to the national defence, the requirements of growth of such industries and such supplies and services, including the investment, exploration, and development necessary to assure such growth, and the importation of goods in terms of their quantities, availabilities, character, and the capacity of the United States to meet national security requirements. This is really broad. It's a very holistic understanding of the relationship between your economy, your ability to have the resources and capacities to conduct your defensive needs, and the impact that trade relations can have on those. We didn't think a lot about those during the 2000s and 2010s, but they're very much at the forefront of everyone's mind today. So look, that tool was relatively rarely used in modern era before Trump applied it. So the last time a Section 232 before that had found a threat was under the Reagan presidency in 1986. So that was still Cold War era. So the Department of Commerce did its investigation. It's quite thorough. I suggest having a read of it. It's a really interesting and detailed document. It sets out how that Section 232 had been used appropriately in line with historical usage within the US. And also that report was actually challenged by injured domestic importers who took a case. That was the American Institute for International Steel Incorporated. They challenged the tariffs on the ground that it was an unconstitutional delegation of authority, right? We have another case coming up quite soon on AIPA, which is somewhat similar, but there'd already been precedent that it wasn't unconstitutional. Perhaps they picked the wrong ground, but they lost that case. So the tariffs stuck, they're in place. At the time, again, trade scholars were straight away saying this is just protectionism. It's an old industry, all well connected. This is classic protectionism. The UK's International Trade Secretary, Liam Fox, at the time called the tariffs patently absurd and just protectionism. EU Commission Jean-Claude Juncker described the tariffs as a bad day for world trade. So I think these responses kind of missed the reality of that there was something deeper going on here, and it's what we're all facing today, which is economic security. So let's look at the WTO case then. So Article 21, which is about essentially your security interests, and it says to prevent any contracting, nothing in this agreement shall be construed to prevent any contracting party taking any action which it considers necessary for the protection of its essential security interests, And then there's 3 enumerated paragraphs relating to fissionable materials, traffic in arms, and time of war or other emergency. Look, there's a long-standing debate within trade scholars as to whether that can be defined and interpreted as wholly self-judging, which has been the US's position since the late 1940s, early 50s. Although it did initially agree to the enumerated paragraphs, it's very quickly seemed to disavow them. But some scholars say it's wholly self-serving. Others have said no, the enumerated paragraphs are there for a reason. And so, but it was never tested in actual case, right? So it was a really important case then in dispute settlement 544, certain measures on steel and aluminium. A number of countries actually took cases against the US again, so a lot of countries did think this was illegal, and protectionist allies and other countries alike, and that case is actually the DS 544 by China. Okay, so the panel defines so essentially, actually going back one step, the US continually said, look, we're wholly self-serving, we're not even going to justify this. They wouldn't give a reason, and eventually under panel proceedings, they actually did give positions that most logically it would refer to a enumerated section B part 3, which is the time of war or emergency. So the panel was happy to finally have something to bite into and actually try and make a decision on this. So they actually, in their case, to detail this, they tried to they define an emergency, danger or conflict that arises unexpectedly and arises urgent attention, a condition requiring immediate treatment. So this is just a common definition of the term emergency. So then they look at the idea that the justifying provision, war or other emergency. And so they said the US has acknowledged it's not war. So it must be another emergency in international relations. And then so they said, okay, well, if war comes first, the other emergency must be somehow equivalent or parallel to the extremity of the war. And so once they got to that point, they actually had an unfavorable conclusion. So the panel is not persuaded that the situation to which the United States refers rises to the gravity or severity of tensions on the international plane so as to constitute an emergency in international relations under Article 6IB3. Okay, so that was obviously then there was a scathing rejection of that report from the Biden administration. So now this has gone across 2 different administrations, very different administrations, different approaches to international relations, but both are willing to stay committed to this Section 232 tariffs on national security grounds. And the Biden administration was absolutely scathing, and its USTR representative in absolutely rejecting in uncompromising terms the legitimacy of the WTO ruling. So now the WTO has ruled against its largest member, is at loggerheads with still the most important country in the international economic system, and the world, for many countries, the most important security ally. So what should we think about this, and what does it tell us about the challenges in multilateralism, right? So initially, a lot of people were skeptical of those Section 232 tariffs. Economic security as a term had become popularized. We're in a very different world now, and I think those were actually a harbinger of the world we're in, and actually presages that the WTO needs to do something very substantive in changing its approach to Article 21 or finding a workaround if it doesn't wish to find itself in ongoing and expanding tension with all its members, who are increasingly going to start introducing economic security measures that already have and are developing frameworks along those lines. So if we're in a geoeconomic era, as a lot of scholars now talk about, power politics by economic means. So instead of looking at the economy as an area where you try to liberalize, governments are increasingly trying to close off, right? Because that's what security is about, protection. It's about reducing vulnerability. This goes counter to everything that's in the MFM, because you're inevitably going to cut across most favored nation positions. Also, the concept of a Cold War is useful, right? How long is this? Is this going to last as long as Trump 2.0, or is this going to last 5 years? Or are we looking at decades, right? The original Cold War was half a century, right? A Cold War in IR relations is actually a competition between 2 competing countries who are nuclear-powered countries, and so must not enter a hot conflict, right? So it's a modern phenomenon. They must compete with every other means they have for relative power balancing, relative gains and losses. So once you start thinking about relative gains and losses, if you need to do something economically damaging to your economy, but it actually creates a slight relative gain to your competitor, you will do that, right? Because the existential need is greater than a bit of economic damage. That's where we need to change how we think about this world. So economic security is a fundamental phase shift in how we think, but also how we need to think about the new economy that we're in, the world that we're in. So I think the challenge, okay, so other major countries, the EU has an economic security framework developed. Japan has an Economic Security Promotion Act that has a Minister for Economic Security. Australia doesn't have a formal economic security framework, but it's absolutely moving in that direction. Foreign investment review screening is now done for national security reasons that are geopolitical in nature. It has a Future Made in Australia Act, which is all about sovereign capability and will inevitably involve discriminatory subsidies. I would argue some are in place. Government won't admit that currently, but the Productivity Commissioner very recently just made comments about some of these increasingly big subsidies to industries. So the WTO is in a really big bind, right, to conclude all this. It's facing an economic security world where it has defined away the right of its members to actually engage in economic security actions. So what this will mean is that as cases are increasingly taken against countries who say they're acting in their essential economic security interests, there will be more and more cases where the countries will refuse to act in accordance with a panel finding. They will reject the WTO's ruling because no one will give up their essential security interests. And the WTO will be increasingly undermined by that activity. So there has to be ways around this. Maybe you can negotiate agreed criteria for Article 21 exceptions between members and agree not to challenge. There's also ways of using safeguard provisions for rebalancing. And some sorts of rebalancing for any suspensions of most favored nation existing concessions. So I'll leave it at that and looking forward to getting some challenging questions.
Thank you, and good morning to everyone. I will be first to say, of course, that I speak in a private capacity today and on behalf of the Commission. And well, generally, my purpose today and also here at the conference is to try to bridge the gap between what I observe working on economic security and trade strategy towards China in DG trade and the wider academic debate, including more broadly what this implies for the future of the world trading system. And I think as has been observed multiple times already during this conference, our work is becoming more geopolitical, a bit less legal, and so I apologize in advance that my talk will also be more on the geopolitical side, but I hope that this can also inform some of our legal debates that we are having. And my observation so far is that this geopoliticization is being driven by two trends in the EU-China relationship. And first, whereas we used to be in an era of convergence of values and policies with China during its reform and opening up period, we are now moving to an era of increasing divergence and systemic rivalry. And this is creating a fundamental lack of trust. And second, at the same time as trust is eroding, we are trading ever more connected goods and data services, which actually requires an increased level of trust. And these trends have sparked economic security responses from both the EU and China. But my contention is that China has moved in this direction much earlier than us. And what I'll do in my presentation today is to first briefly zoom in on China's thinking on economic security. Second, how this is exacerbated in a way by the fact that China never fully liberalized in the first place. Then I will use export controls as a case study to illustrate this. So starting with China's thinking on economic security. As in all authoritarian states, arguably, regime security has always been central, as has, specifically in the case of China, also self-sufficiency. But I think few would disagree that Xi Jinping has accelerated both of these trends since he took office. So in 2014, he introduced the concept of comprehensive national security, which he identified 11 areas of security, which were later expanded to 16 and then to 20 in 2022. And political security is explicitly being ranked as the most important, with economic security as its foundation. And furthermore, in 2016, Xi Jinping also explicitly called for the development of supply chain and technological choke points. So while the Trump 1 and Biden administration may have sped up this securitization trend, its origins clearly preceded Trump 1, and economic security has arguably been a core CCP concern ever since MAP. And moving to my second topic, namely China's incomplete liberalization, as this increased securitization, politicization, and I would even say ideologicalization of Chinese society took hold under Xi Jinping. Economic reform has stalled. And already under President Hu Jintao, we saw that the slogan reform and opening up fell into disuse. It has made a return in the past 2 years or so, but mostly for foreign audiences. And this has been at the same time as China has introduced new national security laws, were detaining researchers, preventing cross-border data flows, and also was shutting down debate and democratic freedoms in Hong Kong, as opposed to what it could have done is to open up the mainland further. So this slowdown of economic reform means that China retains several of the non-market aspects that it had before. So it continues to have and has even increased the SOE dominance of the Chinese economy. And I think their Professor Mark Wu's paper on China Inc. is still very relevant. Also, as we heard from Professor Schaffer's opening remark talking about the rule of law, China rather has a rule by law system. And because the CCP is not strictly bound by Chinese law, China does not really need a legal basis to act. It's very different from my position. And if there is no legal basis, then there is no formal measure, and hence a legal challenge, including in the WTO system, becomes very difficult. So that means there's very little real accountability through WTO or other treaties. And domestic courts are also not accountable. And for example, one of the examples is this anti-suit injunctions case that the EU has recently brought. And we can get into some of those examples later. What I want to move to now is to look a bit at the export controls, which I've been following closely in my work. And I think they illustrate both of the two trends that I've illustrated. So the first one, the increased securitization, and second, how the system never fully liberalized in the first place. So on the first point of increased securitization, so starting in July 2023, China put in place export controls on multiple critical raw materials, germanium, gallium, and then many others since then, before the latest control that came into force in April on rare earths and permanent magnets. And the problems with all of these controls is that they are very far upstream, and this makes them broad by definition. They are raw materials. However, even for materials where we have export controls as part of the Waseda agreements, which, for example, rare earths is not in there, but for example, for germanium and gallium, the technical parameters of China's controls tend to be much wider. And China does not only justify those controls based on national security concerns, it also refers to national interest. So the consequence of this breadth has been a profound impact on civilian supply chains, and most especially for permanent magnets. And regardless of whether the current disruptions, which are still ongoing, were intentional or not, they were at least very foreseeable. And China has refused to suspend the controls or amend their scope in any significant way after we saw that these supply chain disruptions materialized in a very significant way. And moreover, in early 2025, China enacted a domestic track and trace system for rare earths that had been in the making for a few years already. And in addition, as most of you will know, for the past decade or two, China has also invested in extraction and refining raw materials across the world. So what this points to is a systemic attempt to build up supply chain leverage. And now we see this being triggered and China actually using that monopoly power. And what we see more broadly is clearly an attempt to create a new normal of constant border checks and a de facto quota system on export controls or via export controls of critical raw materials. This has kind of been growing year by year. So Arguably, this is highly antithetical to the WTO system and implies a fundamental insecurity and mistrust of the global trading system. The same applies in a way to China's technology controls, and this is where securitization meets the incomplete liberalization that I mentioned. First, some of China's CRM export controls that they brought in also included export controls on related technologies. But more importantly, China maintains a catalog of restricted and prohibited technologies that were first issued in 2001, which is completely separate from the dual-use regulation. And official discretion is so broad that in essence, any type of technology can be listed as part of this catalog. And perhaps not coincidentally, in late 2024, China expanded the catalog to cover technology for the production of rare earth permanent magnets. And in December 2024, so quite recently, it further proposed draft restrictions on technologies for electric vehicle battery production and lithium processing and extraction. And these 2 points remain as draft proposals, but there were already reports in the first half of this year that companies were starting to refuse to export these. And then, just to mention as a last point, that these restrictions are also complemented by restrictions on people. And indeed, 2 weeks ago, the press reported that there were travel restrictions put on Chinese rare earth experts from leaving the country. So if there are people here studying up on investment screening, it's important to recall that China has had such a system for decades in various guises. So to conclude, this inevitably brings us to a zero-sum environment and what we may call a global race for choke points. Of course, the United States has also been wielding export controls and other means of leverage very widely. But China's economic security and self-sufficiency mindset has been there for a long time, as I already mentioned. And what we're seeing now is merely an acceleration. So China may say that it is saying that it is a committed multilateralist, but judging from these actions, it is neither committed nor consistent, but rather an opportunistic multilateralist. And the problems, of course, for the rest of us, those of us trying to preserve the post-Cold War global trading system, is that we are quickly getting squeezed between these protectionist tendencies in both the US and China. And so how we can respond to this, I suggest we leave for the discussion. Thank you.
Thank you. So Lisa kicked off this panel with an overview of coercive action, and Naoise and Marcus spoke about very specific cases. But I'm not going to speak about specific cases, and I'll bring you back to a broader perspective, more general issues. The objective here is to discuss what measures can be taken legally against what is allegedly economic coercion, or if I use Lisa's words, weaponization of trade. So my focus is rather on response to economic coercion rather than economic coercion itself. But to discuss potential responses to economic coercion, we have to know the legal nature of economic coercion itself. So in the first part of my presentation, I'm going to speak about the legality of what is allegedly economic coercion through trade or weaponization of trade. And then I will speak about, and on that first part, I'll briefly mention WTO related issue, but I basically speak about non-WTO general international law related issue. And then in the second part of my intervention, I'm going to speak about the legal nature of responses to the weaponization of trade. And I'm basically speaking about the legality of countermeasures against economic coercion. So let me start the first part of my presentation about economic coercion. And Lisa has already shown us the variety of coercive action. So I'm not going to speak about what economic coercion could mean. Just please go to the economiccoercion.com. So, about the legality of the consistency with the WTO, those measures that are used to coerce other countries to do something can be a violation of WTO obligations, such as GATT Article 1 or GATT Article 11 and so on. And those measures could be justified under Article 20A or 21. But again, I'm not going to speak about the WTO consistency, and I'll just discuss the possibility of those measures being inconsistent with non-WTO general international law. And there's no explicit rule on economic coercion itself in general international law, but I think the principle of non-intervention can be relevant in this context. And according to the ICJ judgment in the Nicaragua case, the principle of non-intervention is I quote, part and parcel of customary international law. And the ICJ judgment also sort of provides pronounced two conditions that have to be met in order for an act to consider as a violation of the principle of non-intervention. And the first condition is that an act must be one bearing on matters in which each state is permitted to decide freely. So a measure, an act, has to be related to something that has to be left to the free choice of a state, such as the choice of political system, or the choice of social system, and so on. The second condition is it has to have, an act has to have an element of coercion. And according to the ICJ judgment, element of coercion forms the very essence of prohibited intervention. And personally, I think this condition, especially the second one, is a very high bar. And to me, it's probably very rare for an act to actually violate this principle of non-intervention. However, just kind of sum up the first part of my intervention, a single measure, or what is allegedly economic coercion, could both violate a WTO obligation and the principle of non-intervention. So that's a takeaway from my first part. And the second part is a response to economic coercion. And a variety of measures can be taken in response to economic coercion, but I will focus on unilateral trade restrictive measures to respond to what is allegedly economic coercion. And also, I'm assuming that this unilateral trade measure is taken against illegal economic coercion, meaning a violation of WTO law and violation of the principle of non-intervention. Again, from WTO perspective, the response measures could be a violation of GATT Article 11.1 or GATT Article 1 or other TBT or SBS agreements, or they could be justified by Article 28 or 21. But I'll focus on Article 23 of the TSU, because as you know, as a trade nurse, Article 23 of the TSU prohibits unilateral determination of WTO violations, and Article 23 of the TSU prohibits the unilateral suspension of concessions. So taking a unilateral trade restriction measure against what is allegedly economic coercion could be a violation of Article 23 of the TSU. So that's that. And let me also mention an issue related to general international law. And we kind of, there was a panel on countermeasures under general international law on day one during the conference. And there was a discussion about countermeasures. So under the general international law, countermeasures can be taken against a violation under general international law. So if a measure, if what is allegedly economic coercion, is a violation of both WTO law and general the principle of non-intervention, then countermeasures may be taken against that measure. And so here we have sort of a dilemma. On one hand, the response measure may be a violation of Article 23 of the TSU, but on the other hand, that measure may be justified as countermeasures under general international law. So the question is how to reconcile this dilemma. And that was a topic, one of the very important topics in that panel on day one. So now I come to the final part of my presentation. And so it's a relationship between WTO law and general international law, or it's a relationship between countermeasures under WTO law and countermeasures under general international law. And well, if you attended that panel I'm talking about, you know that there's a huge disagreement even among the panelists. And I'm not going to try to answer that very difficult question. The question is whether Article 23 of the TSU excludes the application of countermeasures under general international law, or does Article 23 of the TSU leave room for the application of countermeasures under general international law. So I'm not going to try to answer that question now, but I just want to point out two considerations that have to be kept in mind in thinking about this question. So the first consideration that we have to keep in mind is the use of terms. I think sometimes people sort of do not use the term countermeasures correctly, and they may mix the term with some other stuff. And there are very similar but different terms. For example, sanctions against human rights, or extraterritorial obligation of a national law, or retaliation, or even a plea of necessity. We have to distinguish countermeasures from those similar but different concepts or terms. Countermeasures is an international wrongful act by an injured state against an international wrongful act by another state in order to induce the latter to comply with relevant international law. So in a way, I think countermeasures should be sort of defined in a more narrow and helpful way. The second consideration that has to be kept in mind is the difference of perspectives. And I think when we discuss countermeasures, we tend to think about what a panel would find if a dispute goes to the panel. But and from the WTO panel's perspective, we have to think about the applicable law. Well, in WTO dispute settlement, the applicable law is basically limited to WTO agreements. So a member cannot justify its measure by applying countermeasures under general international law. So in other words, countermeasures cannot make countermeasures or violation of Article 23 of the DSU cannot be justified by countermeasures under general international law. So that's that. But if you take a more broader perspective, if you take a perspective of national decision maker, and then WTODS is just one of your concerns, you can take a broader view. And if you take a broader view, you don't have to think about applicable law, and you can probably say, well, if you go to the WTODS, this response measure could be a violation of Article 23 of the DSU. But in a broader universe of international law, this measure can be justified by as countermeasures. So I think how you see the thing may be different depending on which perspective you take. Yes, so that's all from me. Thank you.
This great. Thank you very much to all of the panelists. We have a little bit of a few I don't want to say pre-planned, but perhaps pre-planned questions to draw out some of the themes before we open this up to a wider Q&A. So building from what Yuka's just been discussing about responses to economic coercion and weaponized trade, Lisa, I wanted to ask from your project sort of mapping weaponized trade, what are some of the lessons learned, particularly in relation to responses by both the government and the private sector?
So one of the interesting things that we did in this project, along with Web2-based service, was qualitative research with different stakeholders. I think that was some of the most interesting values that we mentioned in the project, because it really highlighted first and foremost weaponized trade in services. They are matters of national concern, but first and foremost, they're felt by private actors, and that's the traders who have been doing that. And one of the most important lessons learned from me is that any of the effective trade, very obviously that we can actions in business, but they were not keen to deal with those opportunities that are referring generally to labour and certainly not offering the time to have government engagement in that system. That was quite many industries were even reluctant to comment on their experiences with weaponized trade, fearing retaliation or for licensing and that kind of thing. And they strongly preferred that channeling, also the support and systems of the trusted parties within those private markets. when this shift was taking place. So many impacted traders also highlighted that their best sources of knowledge and support again were not government, but industry associations, which those were the bases where knowledge of governments early and experiences put into the together. That was a very important source of insight into what was going on. And then I think the other thing that was interesting was that farmers felt that they had said, I think it's salutary reminder of the concentrated markets, that very few of them implied that they would make changes to their target markets as a result of their experience in organisation. And still a few I think really sounded like they had considered proactive changes of the business through things like the restriction changes into contractual allocation. And so that for me, I think, is a very promising area of official research for the next stage to how things like inflation to shift spin. And then, sorry, finally, and I will stop. People power in many countries being forward as a really interesting forward, if you like, to the United. And a great example of that was Lithuania's Freedom Cheese social media campaign in response to Russia's 2013 ban of Lithuanian cheese. And so that I think is a very interesting experience in terms of how the industry adapts and works around these situations.
Thanks, Lisa. Continuing on the theme of responses, Marcus, could you tell us a bit more about the European Union's response to China's recent economic security trade measures?
Yes, so I think at a more general level, the EU faces two main challenges with China right now. So first, going back to what I already said in my opening remarks, we are seeing this divergence, systemic rivalry, and consequent lack of trust that is coloring the relationship. Of course, there is still a lot of engagement, but it is coloring the relationship. And second, at a more fundamental level, there is a challenge with China's enormous scale, simply, and the dependencies that flows from this scale in raw materials processing and manufacturing, and also now increasingly innovation. And this has, to an extent, been fostered and enabled under the current open trading system. And what has happened is essentially a concentration of dependencies on China. And some dependencies are both acceptable and inevitable, of course. However, a concentration of very deep and hard to mitigate dependencies in a single trading partner, that can start to pose a problem. Even more so if a trading partner has sort of weaponized those dependencies in the past. So we saw this happen with Russian gas, and we see that now, at least to an extent, although it's still early days with the rare earths. And of course, with respect to China in the past, which we've already mentioned, we've seen the Lithuania and other incidents where there has been weaponization. So in response, of course, the Commission called for a de-risking strategy already back in 2023, and this was then further developed into the three pillars of our economic security strategy, which are protect, promote, and partner. And I do think the partnering dimension is crucial to deal with the challenges of both scale and dependencies when it comes to China. And essentially in two ways. So you can mitigate existing dependencies. You simply need increased diversification, right? What you need is China plus one. That can be other markets. That can also, to an extent, be your own market. And what we've been doing, of course, we've been relaunching multiple FTA negotiations, too many to mention in these brief remarks. We now have clean trade and investment partnerships as an alternative on the table as well. And we've been doing critical raw material partnerships. And then secondly, to meet the challenge of scale, you, of course, have to try to match it as best as you can. And I think this essentially means some version of friendshoring, especially for the most sensitive technologies, going back to what I was saying about the need for increased trust, at least in connected goods. And there, of course, you're looking at increased collaboration on research and subsidies on standards. And I would say that our approach has been to first do 4 general risk assessments under our economic security strategy. I think this was the correct way to proceed, but it has slowed us down somewhat towards the next step, which would be to actually mitigate some of those risks. But I think we are more or less on the verge of turning to real mitigation measures. And yeah, this would indeed include such developing joint standards, marketplaces, and things like this. And there were some positive indications along these lines at the recent G-Summit in Canada. And maybe just to finish, to say just a quick word of what this means a bit more for the global trading system, since we're here at SIEL. And of course, the EU continues to see the WTO as a crucial backstop and the only set of guardrails for managing global economic competition that we have. But over time, I think it's inevitable that rule following will decay, and that is what we're seeing. So what you need is a deep reform and upgrading the rules to remain relevant, and the EU has been calling for this for several years now. Of course, China more prefers the status quo. There are other WTO members who engage in issues linkage, which makes reform more difficult. And of course, the US has not engaged, neither under Biden and of course now under Trump. He has not left the organization. Let's see what happens, but of course, it's not looking that bright. So to finish in that context, of course, the economic security agenda of the EU will not replace WTO, but as we are squeezed between the very active economic security agendas pursued by both the US and China currently, we will inevitably continue to pursue our own economic security, I think, in parallel and in partnership with more like-minded countries.
Thanks very much, Marcus, and thank you for this wonderful segue with your discussion of the WTO rules into our next question. It's almost like you knew what was coming. So back over to Nisha now. What does the Section 232 case tell us about GATT Article 21 and about how the limits the WTO rules place on members managing economic security?
Well, I think it's not hard to see the quandary that the WTO faces in dealing with national security, economic security. Essentially, when that article was devised, there was a fear that if you just had a very open national security rule, that it would be abused, that people would be claiming national security left, right, and centre, and that it would just allow a protectionist kind of momentum to build up. So that's why you have the enumerated paragraphs that are really trying to say, okay, the member can decide its national security interest, but later with the WTO, the panel is going to be able to decide what the limits. Now, in the GATT era, there was very good restraint on this, actually. There was a couple of infamous cases. One in Sweden wanted to protect its shoe industry, and it claimed this was a national security interest because the soldier needs boots. And if a war broke out and they didn't have a shoe industry, they'd have no boots, and then they wouldn't be able to wage war very effectively. But other than a couple of cases, was really good restraint. And so if you think about it that way, at a certain limit, and in a certain way, it's the rules around national security are dependent on the goodwill of members and are dependent on the members seeing the benefits of trade. So if you start to remove goodwill and a view that there's a benefit to you in this trade, and I'm not just talking about economic benefit, there can be economic benefit with a security disbenefit or vulnerability. Once that calculation starts to change with the members, the enumerated restrictions are almost irrelevant, right? Because again, the first and primary job of the government is to secure the ongoing viability of the state. We tend to forget that in periods of peace, which in human history are relatively short often, right? And we don't need to look very far. We don't need to look to history. We can look today. There's wars all over the world today, and some of them are to do with major powers or superpowers, right? And Taiwan contingency is obviously a big factor in this country, right? So we don't need to look to the past. We can see the present. History will also tell us the same thing. So what I really found interesting in thinking about economic security is the WTO and its members can't keep parroting the same lines about the rules-based order, right? And a lot of people do this. I can understand why you want to hold on to something that worked very well for a period of time. But if you don't update and look at how the context changes how people, governments, and institutions interpret laws, right? Because the language is ambiguous by nature. Laws can always have scope for interpretation, no matter how tightly defined. So the changing wider context actually changes law into a new, puts settled law into a new domain of socially contested law and new interpretations that can be reasonable and logical. And I think that's where we're at. So if we're not able to understand that the role of geopolitical peace for the success of multilateralism is fundamental. And that's what we've lost. We don't have geopolitical peace any longer. And so being able to reduce the amount of tensions and keep what you have within the multilateral level, for me, requires recognizing that change and then trying to figure out ways to mitigate and attenuate some of the tensions. And so I think that's where the conversation needs to be at around Article 21 and finding some sort of scope to manage that in a world where economic security is front and center.
Thanks, Nisha. And now a final question back over to you, Yuka. In your presentation, you spoke a lot about the sort of dilemma or tension that's created between Article 23 of the DSU and the general public international law and countermeasures. Do you think we need reform of the WTO rules in this area, or would that be productive?
Thank you. In terms of the WTO reform, I think I'm going to say two things. One is directly related to the dilemma between general international law and WTO law, but the other one is related to the what Nyasha just mentioned. And I totally agree with what Nyasha said about the context is different now from when the GATT was originally drafted. And we have to do something to adjust the Article 21 or other system or obligations of the WTO law that to make them better fit to the current situation. For example, we could probably clarify the meaning of Article 21, or we could sort of create some kind of a new system to allow members to take sort of a rebalancing measures against security-related measures, or we could probably think about excluding security-related measures from the scope of dispute settlement. But in reality, it's probably super difficult to agree on those amendments or clarification. So I think it's probably the best way is to take a more flexible interpretation to give some discretion to WTO members, or to allow some room for coordination between security related measures and the trade measures. But the other point that I wanted to make is the dilemma between WTO law and general international law. And I think in an ideal world, everything will be harmonious. WTO law works perfectly harmoniously with international law, and perhaps countermeasures under general international law will be allowed in WTO law context. But I think it's not, that's clearly it's not the case. And when I think trade law scholars tend to think that general international law is sort of a more perfect, more beautiful. And if trade law is not functional enough, we can go back on the general international law. But I think incompleteness of international, incompleteness is an inherent nature of international law. So it's good to have coordination. It's good to resolve the dilemma between general international law and WTO law, but it's inherently impossible, I think. But it's inaccurate, I think, to argue that we can sort of bring coherence between international law and the WTO law. So it's just important, to me, it's just important to acknowledge the existence of some sort of inconsistency between these two systems.
Thanks to all of our panelists being remarkably good at keeping to time. We have a nice amount of space left for Q&A now. So over to the audience, and I'll gather up 3 or 4 questions. What's great? 4 hands. So I'll just go across the room for my results. Yeah, if you can please just identify yourself.
Samjin Kang from China, South Korea. I have a question and comment, brief question and brief comment to Lisa about the Section 232 WTO case. When I read the case, it was clear that the U.S. viewed that this was inconsistent with the WTO law, and at the same time, GATT Article 20, the interpretation of the GATT Article 21, essential security exceptions was too restrictive under in the previous case of the Ukraine goods in transit case. So as you know very well, the case is in limbo by the U.S. Appealing to the appellate body, which is hollow. And do you think there was any value to the challenges in the WTO dispute settlement in this case in reality? And then so for me also, this reminds me of another case between China and the Philippines before the PCA. Philippines won the legal case because China simply refused to show up. But in reality, what's happening in the South China Sea, the PCA case did not work to resolve the case. So so I think that there's a similarity between these two cases, and I want to hear your thoughts about it. Your thoughts about it a little bit more. Thank you.
We'll gather up a few more questions. So down to Wolfgang and then.
Thanks. That was really. I would just like to appreciate the post that the fuel law is wrong. So what we should do about it. A charitable reading of the fuel law would say that, in fact, there's a lot of flexibility that the fuel law provides to members. The fuel law is arguably a little harsher to how the two members try to achieve these goals. For instance, steel and aluminum procurement, which is carved out from one of the transformation obligation. You could potentially have subsidies, or you can have building up industries. There are other types of measures that arguably the rules push based into those directions. So I'm a little bit confused still. Do we need new rules? Did the initial rules get the balance wrong? Were the initial rules too ambitious? Have times changed so much that we need different rules? So just a little bit more clarity on these points.
Okay, there are a couple of hands that sort of here, so we'll go here and then.
Thank you for the wonderful panel. My name is Yoshimitsu Shishikawa from the University of Shizuoka. And I have a question about economic coercion. In recent years in Japan, over the past few years, in Japan, the economic coercion has been long discussed in Japan. But in terms of China, so many scholars assume that it is mainly China that will be resorting to the economic coercion, and that view is kind of very strong in Japan because Japan has experienced such measures from China. But nowadays, over recent years, as everybody knows, it is kind of the United States which has been using the economic coercion. So my question is, does this change somehow lead us to change or devise the way we analyze or the view the economic coercion issue, especially the legal point of view, such as the countermeasures? That is my question. Thank you.
Sorry, we'll take one more question now, and then we'll have a second round of questions. So we'll go to the hands.
Thank you. I'm Sue. I'm a PhD candidate at University College London. And I actually have two questions, if that's okay. So one for Lisa, one for you. The question for Lisa, first of all, thank you very much for the fantastic project. I think it's a nerd personality saying that every time I hear there's a database, new database going live, I quite excited. Yes, so my question would be perhaps to follow up on this question earlier to you. Could you share more about the international laws of state practice? International law pathways to respond to weaponized trade perpetrators. Maybe one or two most interesting examples we've seen in your research. And the question for Yuka is, potentially related to what the others are asking at the moment. So the tension, or whether there is a conflict actually between the SB Article 23 and countermeasures in the law of state responsibility. I guess it's a subject that has been around perhaps ever since the conclusion of the DSU. So what new perspectives in your review does the context of economic coercion bring to this discussion? Thank you.
Great, we're able to start with at least a couple on the table, and if everyone can try to keep their remarks to a couple of minutes, that means we have time for the second round of questions.
That's my Weaponised slightly different to some of my panelists here, but based on what I saw, the main types of international response include still surprisingly WTO action. And obviously the question then is raised is, well, would some sort of reform in the WTO system or changes to the WTO standard principles help mitigate weapons trade? Overwhelmingly, the answer that I myself have been to know that actually the existing substantive rules are fine for capturing most examples that effectively trade rules that we have about Article 23, but a lot of examples of really big motivated discussions of power. So for me, national security category at all. And really, again, it comes down to having procedurally effective forms of disputes available. As always, the committees and specific trade concerns mechanisms are always the unsung heroes of the WTO system. And they do have ways for urgency things to reduce to work, but I think it's important actually not to overlook those. But I do have, I think, quite a bit of scepticism whether economic legislation is an effective way of trying to deal with trade. We're talking here about a political issue, not a legal issue. And we're talking about the issue of trust and erosion that sort of grand bargain international trade. That's what's being expressed in that sort of legislation for change in the international system. That's just my personal view.
Yeah, thank you very much for those questions. Did you mean the South China Sea case, the exclusive economic zone? Yeah, okay. Is there a value of taking place against the United States today? Probably not, because of what we've learned, and simply the tariffs may not be challenged. But look, if that case was taken when things hadn't deteriorated so much, and where people were still unsure about how far along the road the US was moving in terms of being willing to breach WTO rules for its national interest. And so if someone breaches your MFN concessions in the WTO, what do? Take a case. That's the natural and most logical thing to do. And I think also because people were becoming more aware of the geopolitical tensions, that case kind of needed to be taken one way or another, eventually to find out where the WTO would stand on that and what that would mean for the membership going forward. We know that the WTO was very reluctant around that case, and the panel was holding off and maybe hoping there'd be a geopolitical sea change suddenly, and would save them from making a decision. But they had to make the decision, and also that decision offers other countries leverage to negotiate with, even if initially or for a long period of time the partner country is not planning to remove it. It still sits there and can be used in future negotiations if things change for the better. Things change with the appellate body. I'd be very skeptical in the medium term. There'll be positive changes there, but you still have to log those issues, and you have to put them through the system one way or another. At least we have some clarity now around Article 21. The Ukraine traffic in transit was another one that also disabused Russia that you could self-judge, right? So that was the first kind of rejection of the self-judging claim. They did one on the fact that there was a war, which they'd caused. But still fit within the criteria. So we know a lot more, and that's very useful. But yeah, obviously, if a big, powerful country is determined not to abide by a WTO ruling, WTO doesn't have a police force or a judiciary, or it doesn't have an army to go and actually enforce that, right? And so that highlights, these situations highlight the ultimate lack of power at the international level. Sovereign countries are the bosses of the system at the end of the day, and the great powers of the ultimate right of refusal, basically, right?
Yes, maybe touch on this question on the US and China interplay there. I don't think there is that much to say. Of course, can be said is so under, for example, the G7 presidency of Japan. There was this platform on anti-coercion that was established and so on, where US also participated, right? And has continued, it's quite active under the Biden administration, has continued the Trump administration to partake in those meetings. But of course, this becomes very difficult. I mean, the current US behavior just makes it very difficult to try to establish some kind of norms around coercion. And I think that's regrettable. I think not much more to say. Yeah.
Thank you very much for the great questions. The questions are all great, but if I may, I try to briefly answer all of them, if I may. Just briefly, for the first question, well, to me, international court decisions are binding. WTO panel decision, if adopted, binding. This is our conception. But I think, to me, the value of reports, panel reports, the value of law, the value of court decisions are more nuanced. Because even if a panel report and a binding report are adopted, and even if they are adopted and binding, how to take those reports depend on the state's will, members' will. Even if China, for example, accepted the South China Sea decision, it's eventually up to the parties how to deal with the decision. So we can't think like this is binding, this is not adopted, this is not binding. It's more nuanced. If you think that any if you think non-adopted panel reports have no value, it's too sort of simplistic to my mind. So I think we have to think about more nuanced long-term effects of panel reports or court decisions. And the second question about are the initial trade rules too ambitious and so on? I think it's not about rules. It's not about the substance of rules. It's about implementation of rules. And I think in the gap era, implementation was more flexible. But then during the WTO era, everybody has sort of gaining authority and so on. The implementation was becoming more strict. And now we have a sort of backlash against very strict implementation. So maybe we have to take more flexible implementation approach. And that is sort of my response to the second question. And the third question about Japan, I think economic coercion is more about the narrative rather than legal definition. So when Japan used to say that China was engaged in economic coercion, it's more like it's not like Japan is saying China is violating international law. It's more about political narrative. And because of that, Japan cannot now say the US is engaged in economic coercion, because politically it's not, impossible for Japan to say that. So to me, I think from my perspective, countries should be more cautious about using the narrative economic coercion. Yeah, so that's my response. And the final one, well, Article 23 of the DSU was hailed as a major achievement of the Uruguay round. What has changed is just the context, I think. In the past, we don't have to worry too much about countermeasures under general control. But because of this functioning of the G7, we have to think about countermeasures under general international law. So what changed is just the context, not Article 23.
Over to our second round of questions. We'll start down. No, sorry. Yep.
Thank you very much. Enjoyed a very interesting discussion. My name is I have a question about how to address a lack of trust between members. Yeah, I think the core issue is the lack of trust Sorry. Like you mentioned, and I think the US wants to, there is, that's where they're not still the market want to establish their own companies. And I think the question, how should the US do other parts? Other than like speed and working and I think the second line of question is I think it's not only US that wants to have some you have seen the competition with foreign I think as I said yesterday, the people wants to have some room initial trading system they want to need, they need some support. Then they see in these for that purpose, I think that in WTO provides for the like that safeguard the safeguard measures once the safeguard measure was could be safeguard agreement may have enough you know we can of the development by then the safeguard measure not be used for that purpose. And that remains Article 28 which makes some progress when it comes to the grounds list about I think what I like is that we use difficult things for these policies.
Thank you very much. Go here. And then
Thank you very much for a very interesting. I'd like to hear whoever would like to offer views. But whoever would like to offer views, how would you see as possibly inadequacies or limitations about relying upon the to dealing with this as a response, as opposed to pushing the tension out further at the church.
thank you very much, John.
Thank you. I have two questions, but I'll try to keep them very short. So one question on Article 21 and the case against Section 232 measures. I wonder what are your thoughts on certain space that was provided by the panel in terms of accommodating economic interest within Article 21. I think if we read these reports, we see that it was in the specific context of Section 232 measures relating to, one specific steel industry. But when the panel was addressing the issue of economic interest, it seemed to suggest that if they would amount to a certain level of gravity, they could actually be covered by Article 21. So I wonder, what are your thoughts, assuming that this unadopted panel reports have some value, which I would like to think they do have, do you think that we could build on what is already provided in the report for any future case? And I have a quick question to Lisa. I was wondering if in your research, you have seen any examples of a litigation against coercive measures, also in context of domestic courts. Thank you.
Great, and then over here, just on this side of the aisle, and then I see down the.
Thank you. My name is Margaret. Singer. I also want to get back to your questions and especially on Gustafsson, because you said that what China is doing is antithetical to the WTO rules, but you also said that there is no real accountability of China at the WTO, but also the EU and China take part in the MPI AAA, as far as I know. So is the position of the Commission then, or of the EU, or is it just your factual assessment that there is no real accountability of China at the WTO? And if it is the position of the EU, are there any proposals for reform? Because the chilling of the relationship between the US and the WTO started way earlier. You can trace it back to the Obama administration, and it sort of got accomplished during the first Trump administration. But we have yet to see in more than a decade any genuine proposal for a reform of the WTO from the part of the US. So is there anything in the works at the EU?
One last question down the back.
Thank you so much. My name is Benjamin Lee. I'm a PhD candidate at Water Institute, University of Perth. I have two questions, one for Professor Fukunaga, one for Mr. Gustafsson. So first question, with regard to the dilemma of the Article 23 of the SU and the General International Law. Part of one of Article 23 actually have qualifier terms, which says that a member, when they seek the redress violation or benefit but it's under the covered agreements. So do you think that there's a solution to the dilemma that we can actually tear apart what actually constitutes a coercion and actually agree with, would you say that coercion could be the narrative? So we zoom into what constitutes coercion, and then we seek redress under for those measures under the covered agreement, and then those outside of the SU scope of that's the appendix of the SU. And the question for Mr. Gustafsson. So, as you mentioned, that China's policies progressing towards making more of a self-sufficiency, but as we can see that the EU trade policy also changed from what it claimed in 2015, saying it's trade for all, to 2021, which has three keywords: open, assertive, and strategic. So do you think that there's a global trend, actually not for certain countries, but a global trend that countries in the world now support more about self-assertiveness other than open to trade for all? And thank you so much for your answer.
Okay, great. Yuka, you have to start with you this time. Work your
So, because of the time limit, I'm just gonna address the question that was addressed to me, which is the last one. And I think one way to sort of avoid the dilemma would be to take sort of a narrow approach to the interpretation of Article 23 of the SU. So, considering that Article 23 is, like you said, it's about to redress, seek redress for violations of the covered agreements, so the scope may be limited. But at the same time, well, this is something that was discussed in the panel on day one. When a single measure is a violation of both WTO law and in general international law, we cannot separate two. To me, we cannot separate two characters, and we can say, okay, now this measure is just a violation of general international law, so we can just forget about Article 23 doesn't apply to this measure, and so I don't think we can sort of divide two characters, meaning WTO violation and general international law violation clearly. So, well, I agree that the narrow interpretation of Article 23 sort of narrows down the scope of Article 23, but that I don't think that sort of solves all dilemma that exists between general international law and the WTO law.
Thank you. Yeah, there's not much time, so yeah, there were two questions I think directed towards me. So first on first just reiterate, I'm speaking in my personal capacity, right? So don't think this is the Commission decision, and these are observations coming out specifically of what we're seeing in this economic security trend. Now, we of course continue to work quite closely with China in the WTO, and I mean, the MPIA is, of course, very helpful. But we see that more and more it can become harder to even challenge China's cases. This we've seen in a couple of instances. I mean, for example, which was mentioned as well, the Lithuanian case, right, where you have this kind of very informal measures. That's more difficult, and there is a lot of case law, but it's a very complex case law on how you bring these kind of informal cases, right? So that's maybe is needing a rethink if we really want something effective. And whatever reforms we're thinking about, I think that we'll have to grapple with these problems. There is kind of a much more general universe out there, whether, you know, it does make sense to have this kind of treaty-based system with a partner who is not rule of law based, right? So that, I think, is an important thing to keep in mind. But there are many cases where it works, of course, where things can be challenged and where we do have dispute settlement with China, and I think that's very valuable. And I do think that speaks to China's commitment, at least in part, that they've actually joined the MPIA. That is, of course, very welcome. Proposals for reform, I mean, there is a lot of thinking going on, but at the moment, I mean, we have this deliberative proposal, and since I don't follow WTO law or the WTO part of the House that closely, I will not really say anything more on that, but of course there is a lot of continued thinking of how we can take the WTO forward. Whether there is a general trend of self-sufficiency, I think so. I think what I tried to explain is also that, of course, the EU is doing a lot of things. I think a lot of that is reactive, right? But it is unfortunately where you end up, right? Which the WTO trying to prevent in a way is this prisoners dilemma where you have a race to the bottom, right? Where the rules kind of decay. But over time as well, this is why you need the kind of reform, because you have to recommit to these rules so that they become a new rules framework that everyone can live with. And that's probably why at some point we really need to put a new framework there. And I think from the first set of questions as well, just to say, Wolfgang, your question was very pertinent as well. Just in general, I see there is a bit of tension between a bit of what Naoise was speaking to, that, you know, there isn't maybe a clear exception of how you deal with dependencies and so on within the framework if you don't stretch Article 21. So if you don't want to do that, can we think about other types of exceptions which maybe you don't find in Article 20 either, so that you can find a more structured response to deal with some of these kind of economic security risks that weren't really thought about, I think, something like that.
So the issue about the question of trust between members, that's a really important question, right? Because trust has to underline any negotiation that one of the partners is going to feel has legitimacy, is going to be enduring. At the moment, the two most important members are obviously the US and China, and they're the two members with the biggest breakdown in trust. It may not be a hopeful view, but I think there's little chance in the medium term of rebuilding trust of that type between those partners. I think what can they trust in each other at the moment, the US and China? They can each trust that the other is out to achieve economic or relative gains, power gains over the other, strategic gains over the other, bilaterally and through partnership relationships. And if you've been watching the news in the trade news recently, so China's been warning countries, do not do a trade deal with the United States that undermines their interests. Section 232, and there's a whole plethora of these now, right? There's multiple investigations. These are starting to be used to link countries' negotiations, such as the UK, I'll give another example as well, to tie in the US's economic security interests into a bilateral agreement that is a fundamental breach of MFN. China's very dismayed about this and concerned. So the UK is the only country so far to get exemptions from Section 232 tariffs on steel. They've gotten quotas for the car industry to export, and they've also gotten direct steel exports to the US that are going to be exempted to a certain extent. So that's a very specific sectoral agreement, which is also in breach of the FTA rules. In terms of Vietnam, they have an agreement now. We don't know the full details, but it's to do with block and transhipment. They're going to get a 20% reciprocal tariff, but there's going to be 40% on anything transshipped from China. We don't know how they're going to calculate that in terms of local content. But that's there, right? So Beijing is saying, well, the US is now starting to ring fences and is making all these bilateral negotiations. So trust is just plummeting. And at the same time, the US is threatening other countries, don't do any transshipment, right? Don't do any deals that is going to allow the China to get around our trade wall, right? So I think this is in a declining level of trust for the medium term. Again, this is, I think, longer term guardrails are the best hope for that relationship, right? Going back to the original Cold War, which has much to tell us about this relationship. Guardrails for managing tensions is what I would see as the medium term and probably long term. Hope. And then Article 21, look, I didn't really see that aspect that you've mentioned, that they were pointing at perhaps that if there was a certain gravity of economic damage, I suppose, is what you're getting at. So afterwards, maybe point me to that. I'd really like to hear more about that. But it still goes back to how they've finalised their interpretation. It does something. Is it an emergency that meets the gravity of war? If you take the recent rare earths licensing controls, right? So global auto industries ran a point of shutting down, right? Because collateral damage, not the North American ones, US, they were targeted, but the EU, Japan, they couldn't get enough rare earths for their auto manufacturing. They're on the brink of shutdown. Would that constitute definition of emergency as defined by the panel as danger or conflict that arises unexpectedly, requires urgent attention, or a condition requiring immediate treatment or pressing need? Yes, but then when you link it to severity comparable to war, that's a bit more difficult to kind of think through. But I certainly think they need to start thinking what would be a threshold in the economic domain that might reasonably meet that criteria.
Thank you, and I like you, I think I'm sure panel address about the trust that converts but also the role of non-large partners, I think we can come together and say, no, this is valuing the international system, not have two largest players between them demolishing this thing, but we still see value. It's like countries like Australia and in that field. I think it's also important, not just as academics, but also in the political sphere to think critically about this whole idea of securitization. So, making everything a security issue and obvious pretty clear in certain situations. I think as one, and it says it marks a topic as a special domain, special policy space to intervene. But should we be doing that? And I've been very much no. The monitoring guidelines, the securitization rapidly sort of enable this environment. So I think something needs to be about now. Jumping over to the question of the litigation, what can I expect to see? Some private litigation, I think especially the use of the judicial review of administrative action type space. My observation is it's just very hard to track because we need to know the numbers of the companies. We want to work out what is going on in different jurisdictions. So that's particularly hard to identify. I would expect to see some private litigation, and I would also expect to see some civil disputes as part of the change, try and work out who is the financial of structured travel levels. So when China's Australian floor tanks were sitting off the coast of China, one of my questions was who paid for that? Where did that loss through be exactly? And what happened in the next iteration of those private contracts and how they press that on. So yeah, lucky one, there's an interest in it.
Okay, great. Thank you everyone for coming along to this panel and for all the wonderful questions and engagement. Please join me in thanking our four panelists and also our assistants and hosts here at MDU who have done so much to make these run smoothly. So thank you very much.